One thing in housekeeping, there was a thumb drive that was presented evidence in the Spencer hearing this morning, and let the record reflect states present, defense counsel, and defendant present. You can be seated. Has that been submitted to the clerk?
It has not. I was considering it as a demonstrative aid to the court. If the court prefers that I file it, then I will. I've got it in my pocket.
I think it was made part of the record and referred to, so I think it's been identified. I would just, yes. All right, and when we left, at the end of the Spencer hearing, the defense indicated they had further argument and potentially wanted to talk to Mr. Wilson about presenting anything further regarding the Spencer hearing.
We don't have any further evidence to present. I can inquire of Mr. Wilson if you would like, but he has elected not to provide any testimony in his defense.
So at this time, the defense does not have anything further regards to the Spencer hearing?
We do not, Your Honor.
All right, is that correct, Mr. Wilson?
Yes.
Okay. Anything else from the state?
No, thank you.
Okay. Then you did indicate you had some argument in regards to sentencing?
I do.
All right.
But we need to approach.
Okay. And as per the sidebar, I know Mr. Wilson didn't approach, but waiving his ability to be up here at the sidebar, and I'll just say what was said, that basically this morning we had a Spencer hearing. At the end of the Spencer hearing, defense counsel indicated they may have further argument and wanted to speak with Mr. Wilson regarding any other potential testimony. We recessed until 2 o'clock this afternoon, and so the court came back in to see if there was any further evidence or testimony, which appears there's not, and if there was any further argument regarding sentencing. Subsequent to that, I will take another recess, and then we'll come back for the court to issue a sentencing order at that time. So that's procedurally where we are. Okay. All right. So is there any further argument then?
Do you want to get voting?
Yes.
Judge, briefly, you've heard all of the evidence, the testimony in the case. On behalf of myself, Mr. Hollander, Ms. Perez, Mr. Wilson, we want to thank you for your consideration of Mr. Wilson's sentence in this case. We understand that when a jurist takes the bench, we hope you don't have to make a decision like this, but we know that Your Honor has paid close attention. You've considered the law, you've considered the facts, the evidence, and you're going to render the decision that you think is just. Obviously, either sentence is a terrible sentence. The sentence of death is worse in that if there is a mistake along the way and we can't correct that mistake, we can't correct the sentence after it's imposed. We'd ask that the court consider the 3 statutory mitigators: the capacity of the defendant to appreciate the criminal nature of the conduct or to conform that conduct to the requirements of the law was substantially impaired. Obviously, you've heard testimony that he consumed quantity of controlled substances. He described it to the officers, said it basically made him almost insane. The defendant requires specialized treatment for mental disorder that is unrelated to substance abuse or addiction or for a physical disability, and the defendant is amenable to treatment. We don't know what kind of treatment that's going to be on death row. We know that he needs treatment. There's testimony to the fact that he's been on treatment. He's been on the same treatment throughout his stay in the Department of Corrections and in the Lee County Jail. He needs that medication. He needs that treatment. The defendant cooperated with the state to resolve the current offense or any other offenses. I'm sure the court recalls that Mr. Wilson provided a statement to law enforcement. At the time he provided the statement, he was not aware that they had located the second victim. He was doing that in an effort to assist the victim's family. They had already located the second victim, but he didn't know that. He provided them with details that, but for his statement, they would never have known. We have non-statutory mitigating circumstances. The defendant was born to drug-addicted teenage parents. The defendant's biological mother suffered mental illness. The defendant's mental illness presented at age 12 and was precipitated by puberty and substance abuse. The defendant was diagnosed bipolar disorder, and I call it schizophrenia. It's a little bit different diagnosis. The defendant is loved by his adoptive parents, Candy and Steve Wilson, who has provided a statement to the court. The defendant is loved by his sister, which was reflected in the statement read to the jury. The defendant was profoundly affected by being abandoned by his biological parents. He's been a loving son to his adoptive parents, as reflected in the statement read earlier today. I remind the court that the jury's recommendation was 9-3 for one victim and 10-2 for the other under their previous statute. that would have required this court to sentence my client to life. Likewise, I would remind the court that Mr. Wilson has been waiting trial for a long time. The unfortunate death of his previous counsel prolonged the litigation and impacted Mr. Wilson greatly. I point out to the court, lastly, obviously the court has received, and I know that you haven't read them because I have received notification from your office that these letters have been received by your office, but I know that the court would not read an ex parte communication, that the letters have been sent back to us, but obviously there are people that have been pleading for Mr. Wilson's life and for the court's mercy. There are some 40,000 people that have signed petitions to that effect. We'd ask the court to take into consideration that death is permanent, death is different, and we're asking the court to impose 2 life sentences for Mr. Wilson.
Steve?
Good afternoon, Your Honor.
Good afternoon.
I'd like to point out, and I agree with the defense counsel, that death is in fact permanent. Christine Melton was 35 years old. Diane Lewis was 43 years old. Both of their deaths were permanent. Back in June, when this court heard the facts and circumstances of this particular case surrounding the deaths of Ms. Melton and Ms. Ruiz, this court should have learned that this case was nothing more than power, control, and violence that led to murder. Mr. Wilson's decisions were not only pitiless and consciencelessness, but they amounted to tragically reducing Ms. Melton as well as Ms. Ruiz to nothing more than memories and photographs, to not only their families, but also to their friends. The only reason why that happened was because they both encountered Mr. Wilson. The state, back in July, went ahead and prepared a sentencing memorandum for the court to consider. The reason why the state did that, Judge, was because the state wanted the court to be aware and point out specifically the facts and circumstances supporting the aggravating circumstances and factors that the jury considered in this particular case, and that the jury specifically found proven beyond and to the exclusion of every reasonable doubt. Specifically, the jury is the one that found that Mr. Wilson was previously or contemporaneously convicted of another capital felony or of a felony involving the use or threat of violence to the person. That particular fact, an aggravating factor, was established throughout the course of this trial by virtue of the verdict that was rendered by this jury when they found Mr. Wilson guilty of both counts of first-degree felony murder and first-degree premeditated murder. Secondly, Judge, the jury found beyond to the exclusion of every reasonable doubt that the capital felony was committed by a person previously convicted of a felony and under a sense of imprisonment or placed on community control or on felony probation. Once again, this court, as well as this jury, received testimony, not only by virtue of receiving certified court roll prints, a certified copy of conviction as business records, but also received the testimony from our crime scene tech who conducted the fingerprint analysis and determined that Mr. Wilson was in fact one and the same of the individuals who was convicted of 2 felonies, that being trafficking in stolen property and false information to a pawnbroker on the 18th of September of 2019. That was less than a month before these murders occurred. That was established beyond and to the exclusion of every reasonable doubt, and the jury concurred unanimously on both of those. Capital felony was especially heinous, atrocious, and cruel. Judge, this particular factor screams for justice. The homicides by which Ms. Melton and Ms. Ruiz died at the hands of Mr. Wilson sets this case apart from normal capital felonies because, once again, it's conscienceless and it's pitiless. And it's unnecessarily torturous to both Ms. Ruiz as it was to Ms. Melton. You heard about the fingernails being broken, the many bruises to their body, or the face, the swollen eyes, the contusions, the bruising all over the torso and arms, the hemorrhages on both sides of their neck, the scalp bruising, the contusions to the lungs, contusions to the liver, to the back of the bladder, to the colon. Her brain was swollen. That was just Ms. Melton. And then we have Ms. Ruiz. She had the fracture of the nasal bone, the laceration to her left breast, her bruising on both sides of her body, the bruising on the back of her left forearm and on the back of her left hand, the fracture of her 4th finger, the bruising on her right arm, the contusions on her upper back, the hyoid bone, the trachea cartilage being broken, the multiple rib fractures in the front and to the back. And then we have the hemorrhage on the back of her neck. And then you couple that with the fact that Mr. Wilson went ahead and placed his hands around the necks of both of these women and allowed their lives to slip through his fingers when both of them knew they were going to die. The jury found that particular factor, Judge, unanimously, as to both Ms. Melton and Ms. Ruiz, that it was heinous, atrocious, and cruel. He overpowered them, controlled them, he silenced them by placing his hands around their neck. Judge, we submit to you that factor should be given extremely great weight. And lastly, Judge, the aggravating factor of it being cold, calculated, and premeditated. The jury found, beyond and to the exclusion of every reasonable doubt, unanimously, that this aggravating factor applied to Ms. Diane Lewis. That evidence that was presented, beyond and to the exclusion of every reasonable doubt, you heard and was corroborated by the evidence in this particular case, statement that was given by Mr. Wilson himself. He asked her where the high school was and if she could show him. He said that once he got her into the car, they'd drive to the school. He was going to drop her off, but he knew in his mind he wasn't going to do it. He started choking her because she started to get out of the car. He could tell that she was getting scared. He saw the fear, and then when she would not die, he pushed her out of the car and repeatedly drove over her and then attempted to dispose of her body in an empty wooden lot. Judge, that is what is precisely the sort of heightened premeditation that's contemplated by that specific factor. And we would submit to you that that particular factor also carries great weight. Mitigation that defense counsel has presented to this court, we would argue, counts for little weight. Not only that, but it's contested, Judge. It's controversial. Everything defense counsel has presented on behalf of Mr. Wilson, whether it be head injury, whether it be psychological issues, whether it be family matters, all of that has been controverted. It has not been substantiated. There was no history of brain injury. It's not documented in any of the medical records. You heard here today Dr. Rubino's testimony. You heard counter testimony from Dr. Coyne. All of his scans were normal. Neuroimaging studies, both pre and post-arrest, indicate normal brain scans, although he'd have you believe that he had injuries to his brain. That is not anywhere in the record. As much as he'd like for you to believe it to be so, it is not. The review of the incarceration medical records do not indicate any type of cognitive problems whatsoever, Judge. You heard testimony by Dr. Eisenstein. That was controverted by Dr. Herkoff. Dr. Eisenstein even went so far as to present evidence as related to the Dallas-Kaplan function system. He tested averagely, Judge. He wants to talk about references to his memory, talking about that he has issues with short-term memory. That's not true. He has an ability to recount events when he wants to. He has an ability to tell stories. He has an ability to make you believe something that isn't true. And interestingly enough, Judge, the neuropsychological testing results are not consistent with any type of neurocognitive disorder. Even Dr. Eisenstein's own tests establish that the defendant's executive functioning, the frontal lobe capability, can be within normal range. Judge, you haven't heard anything in this particular case, as far as any sort of mitigation, that would outweigh any of the aggravating factors in this particular case. The aggravating factors should be accorded such great weight, Judge, that they were proven beyond and to the exclusion of every reasonable doubt as to counts 1 and 4 in the indictment as specifically found by this jury. They, Judge, support and are sufficient to warrant a sentence of death. And they are not diminished by the mitigating circumstances and are sufficient to warrant the sentence of death. And as such, Judge, the state would respectfully request this court to recommend and impose the sentence of death upon Mr. Wilson, because not only is it deserved, but it's earned. Thank you.
Anything else? All right. So this will conclude the Spencer hearing unless there's any other testimony or evidence that either side would want to present, especially defense. Procedurally, my understanding is that we would take a recess at this point and then come back. And at that point that the state would want to present victim impact testimony or no?
Your Honor, I've spoken with the victim's family, and they would like to rely on what was stated at the actual trial.
Okay, so then this would be the final opportunity for the defense to present any other mitigating circumstances for the court to consider prior to coming back and issuing a sentencing order. Is there anything else that you want to?
We have nothing else, Your Honor. Thank you.
All right. And Mr. Wilson, again, your opportunity, if you wish to address the court, you may. No one can force you to. No one can force you not to. Is there anything you would like to address with the court? Okay. Then we will be in recess. It's 2:20 now. I'm going to spend some time on the sentencing order. So we will come back here at 4 o'clock. And I'll present the sentencing order at that time. Oh, another question before we go. I apologize. I know the state presented a written sentencing memorandum. Did the defense, I know you presented orally your sentencing arguments. Was there anything else in writing that you wanted to present?
Thank
all
you.
right. There was a PSI done. Did you all receive the pre-sentence investigation report?
Yes, sir.
Okay. And for sentencing purposes, I know that there were other charges that the jury found the defendant guilty of. If you would prepare any statutorily mandated fines, fees, or costs that are associated with those charges, do you have that? If you don't, that's okay.
I can't recite those, Judge. That's not a problem. I do
Okay.
have a score sheet as it relates to those additional charges as well.
Very well. Have you shown that to the defense?
Yes, Judge, I have.
Any objection to that?
No, sir.
I'll accept that.
Thank
All right, if there's nothing else for the court to consider, then we will recess, and I will prepare a sentencing order and come back here, say, what, 4 o'clock.
Thank you.
We'll be in recess. Fortunately, let's see. All right, let the record reflect that State's President, Defense Counsel, and the defendant are all present. We're here for sentencing. Was there anything else that the court needed to address prior to sentencing?
No.
All right. So I have considered all of the testimony and evidence, arguments of counsel, applicable case law, and statutes. I have prepared a written sentencing order, which I will file contemporaneously with the pronouncement of the sentence here today. I also have copies for the state and defense, which I'll hand out once I conclude. So in the state of Florida versus Wade Stephen Wilson, case number 19 CF 568, the court will read aloud the portion of the sentencing order related to the sentencing circumstances and proportionality. In evaluating the aggravating and mitigating factors, the court does not engage in a mere counting procedure, but instead makes a reasoned judgment based on the totality of the circumstances. In reaching this decision, the court is mindful that because death is a unique punishment in its finality, its application is reserved only for those cases where the most aggravating and least mitigating circumstances exist. The law never requires the imposition of a death sentence. In this case, the totality of the circumstances indicates the defendant, with premeditation, beat and strangled Christine Melton in her home before stealing her vehicle and driving to meet his girlfriend, Melissa Montanez. After Montanez refused to get into the car with him, the defendant battered her in broad daylight. The defendant told law enforcement, when Ms. Montanez managed to flee from the defendant, he fled the scene and drove back to Cape Coral, where he decided that he would murder another person. He saw Diane Lewis walking to work and pulled over, pretending to ask for directions. She got into the car to provide directions, but the defendant strangled her when she tried to exit. He then drove to an empty lot, strangling her into unconsciousness at least one additional time on the way there. When she tried to flee from the car, he drove over her at least one time, inflicting mortal injuries to her spine, ribs, and neck. The evidence showed that both murders were heinous, atrocious, and cruel, and that the second murder was cold, calculated, and premeditated. The defendant inflicted serious physical and emotional pain to the victims. Moreover, the defendant committed murders while on probation for prior felony convictions, and he committed 2 first-degree murders contemporaneously with each other and with grand theft of motor vehicle, battery, and burglary of a dwelling. There were no statutory mitigating circumstances that were established, but the court considered the non-statutory mitigating circumstances presented by the defendant. Out of 13 enumerated non-statutory mitigating factors, the court found that 10 had been established. Out of those established, 6 were given little weight. The totality of the mitigating circumstances indicates that the defendant suffers from drug use from a young age, along with undiagnosed and untreated mental health issues of some kind. He felt abandoned by his biological parents, but had a devoted adoptive family who raised him in a supportive and loving environment. Defendant did not resist law enforcement when arrested and confessed fully to both murders. The court has further considered giving great weight to the advisory verdict of the jury, who recommended that the death penalty be imposed by a vote of 9-3 on count 1 for the murder of Christine Melton and a vote of 10-2 on count 4 for the murder of Diane Lewis. The court recognizes that there is no mathematical formula for considering the aggravating and mitigating factors. It is not enough to weigh the number of aggravators against the number of mitigators. The court carefully considered the nature and quality of each aggravator and mitigator. Having reviewed all of the aggravating factors proven beyond a reasonable doubt and all of the mitigating circumstances reasonably established by the evidence, the court finds that the aggravating factors greatly outweigh mitigating circumstances. Given the facts of the case, nothing in defendant's background or mental state would suggest that a death sentence is inappropriate. This court's review of other reported capital cases has led the court to conclude that the death penalty is not disproportionate in this case. Under the totality of the circumstances and evidence, the court finds no basis to override the jury's verdict. The totality of the circumstances warrants that the defendant, Wade Stephen Wilson, be sentenced to death for each count of first-degree murder. Accordingly, it is ordered in the judge that the defendant, Wade Stephen Wilson, be sentenced as follows. Count 1, first-degree murder of Christine Melton. The defendant is hereby sentenced to death. Count 2, grand theft of a motor vehicle. The defendant is sentenced to 5 years imprisonment in the Florida Department of Corrections. Count 3, battery. The defendant is hereby sentenced to 364 days in the Lee County Jail. Count 4, first-degree murder of Diane Lewis. The defendant is hereby sentenced to death. Count 5, the burglary of a dwelling. The defendant is hereby sentenced to 15 years imprisonment in the Florida Department of Corrections. Count 6, petty theft. The defendant is hereby sentenced to 364 days in the Lee County Jail. The defendant is given credit for all time served on this case on all counts. All counts are to run concurrent with each other, meaning at the same time. All statutorily mandated fines, fees, and costs as announced on the record are imposed, and the defendant is committed to the custody of the Department of Corrections for execution of this sentence as provided by law. The defendant is hereby notified that these convictions and sentences are subject to automatic review by the Florida Supreme Court. If he cannot afford an attorney to represent him in any appeal, the court will appoint one for him. Are there any other matters to present to the court?
Briefly, Judge, say we'd be seeking $17,500 cost of prosecution.
I'm sorry, how much?
$17,500, Judge.
All right. Any objection?
No, sir.
All right. That will be imposed then. Any other terms or conditions?
Absolutely, Judge. We just want to make sure that Mr. Wilson has absolutely no contact with the victim's family.
There'll be no contact ordered with any of the victim's family members and anything else.
Thank you.
All right.
Judge, I understand he has other cases pending.
as soon as possible.
Okay. Well, in relation to those other cases, I know we have cases pending here in the circuit. Today is not the day to handle those. I would maybe put those, I could do it as early as September 16th. I believe that's Monday morning.
That's Malcolm's case. Yes, Your Honor. Malcolm Down from Mr. Wade Wilson. September 16th would be fine.
Okay. Well, I think it'd be more appropriate to handle that at a different time. So let's do that September 16th then at 9 a.m. for the other cases. What's your case numbers?
20 CF 16591 and 23 CF 15499.
Okay. And we have court on the 16th, right?
Yes, Your Honor.
Okay.
Judge, if I may, he also has a VOP warrant out of Broward County, Palm Beach County. I'm going to get in touch with the authorities over there, but if need be, we'll ask the court to ROR him on that VOP warrant so he can be taken up to.
Well, it's not a motion in front of me today, but if you certainly be able to file whatever you want to file, and
Yes,
I'll
sir.
consider it.
Thank you.
All right. Anything else?
Nothing to say, Judge.
All right, sir. Then, Mr. Wilson, you will be fingerprinted and remanded to the Sheriff's Department. You'll be held without bond and for transport to the Department of Corrections when it's appropriate. If nothing else, then we're adjourned. And I'll give you your copies. Original. Mr. Shirley or Mr. Hollander?